New criminal charges have just been added to the Russell Brand case, including multiple allegations of rape and sexual assault involving multiple complainants. But the legal fight I care about isn't guilt, it's fairness. When multiple sexual offense allegations from different accusers are brought into one case, courts face a hard question, one that can decide the verdict before a single witness testifies. Do you try them together or split them apart to prevent prejudice? Today, I'm not ruling on what happened. I'm ruling on how a court should structure this case to protect a fair trial. Now let's jump in. Russell Brand, a British comedian and media figure, is facing criminal proceedings in England involving allegations of sexual offenses, including rape and sexual assault, brought by multiple complainants. The allegations concern different alleged incidents across different time periods. Earlier charges were already moving toward a Crown Court trial when prosecutors brought new charges midstream, expanding both the number of counts and the scope of the case. Brand denies the allegations. No jury has heard evidence, and no findings have been made. That procedural posture matters because the court must now decide not whether the allegations are true, but how they will be tried, together before one jury or separately, to reduce the risk of unfair prejudice. From the prosecutor's perspective, trying allegations together makes sense. Separate trials risk fragmented storytelling, inconsistent verdicts, and repeated proceedings for complainants. Prosecutors may argue the allegations form a coherent narrative and that jurors can assess each count independently with proper guidance. They'll also point to trial management tools, limiting direction, careful witness sequencing, tight evidentiary ruling, one trial carefully managed. Before we go further, one thing matters. This is not about convenience. It's about whether the structure of the trial itself makes a fair verdict possible. Now, the defense argument goes to the core of trial fairness, because the same facts can pull the law in opposite directions. Trying multiple allegations together risks cumulative reasoning. Jurors may begin weighing volume rather than actual proof. Weaker allegations can borrow strength from the stronger one. Bad character inferences can quietly take hold. This is exactly why severance exists. It is designed to prevent guilt by accumulation, where a defendant effectively is tried being accused multiple times, rather than what can be proven beyond a reasonable doubt on each count. Here's the cross-examination that matters. The court shouldn't ask whether one large trial is simpler. The court should ask, are these allegations connected by more than the defendant's just identity? If there is evidence of a genuine, common plan or a distinctive manner of acting, perhaps, yes, one trial. Or are these simply separate allegations of the same general type, involving different complainants and different time periods? And most importantly, can a jury realistically evaluate each and every allegation in isolation? Or does the presence of multiple accusations inevitably color every verdict? Efficiency is not the legal standard. Fairness is. Courts in England and Wales have tools to manage complex, multi-allegation cases without deciding guilt. Judges control joinder and severance, admissibility of bad character evidence, jury directions, witness sequencing, and publicity safeguard. Here's how I would rule. Without deciding guilt, at this stage, based on publicly available information, there has been no judicial finding of a common plan, distinctive modus operandi, or striking similarity sufficient to justify trying all allegations together. Multiple complainants alone are not enough. Absent evidence that genuinely links these allegations Beyond identity and offense type, Joinder risks prejudice that jury instructions will never cure. In that posture, the fair course is severance, or a structured separation, so each allegation rises or falls on its own proof. That isn't leniency. That's how the system maintains credibility. If you want legal analysis without the noise, subscribe. And for additional coverage, turn to crimesdigest.com. And always remember, the truth matters, and so does reasonable doubt. See you in the next case.